and thank you so much for taking time this morning to listen from us. So I will just give a brief overview of the economic environment in ASEAN, together with some of the developments or new things that have come about in Singapore in relation to dispute resolution in particular, and hopefully you'll find that interesting. So as you can see, ASEAN is now growing phenomenally. I think those of us in the industries will know that that's been the case the last few years. And in 2015, there is a lot of hope that the ASEAN economic community will become a reality very soon. And that community is intended to reduce trade barriers between ASEAN countries, to increase trade flows, to increase labor movements across borders. So this has been a plan that has been around for a number of years now. 2015 is when the blueprint is supposed to come to be finalized, and then the vision is that in 2020 it will become a reality. Whether this will happen, it still remains to be seen, but that is the hope, that ASEAN will become one economic union in many ways. But I don't think it will become like the European Union in the sense of political and unity in that way. And the legal institutions, I think, are not close enough at this point in time to be so uniform. So we will see economic development first, and then maybe in the future we might think about other forms of harmonization. So far as French business in Asia or in Singapore is concerned, I was very excited to actually learn when I was preparing for this that there are almost 700 over French companies in Singapore at the moment, and you are our second largest EU trading partner. And of course, in Singapore, we are all familiar with the French labels and the French brands. But beyond that, of course, the oil companies, the telecommunications companies, and the heavy industry companies all have some form of operations in Singapore as well. So clearly, there is a lot of room for us to collaborate with Benoit and his colleagues, as well as with you in the future. Just a very recent example, Singapore and Kuala Lumpur in Malaysia, we are developing a sort of high-speed railway between the two countries to foster greater development. And it's very interesting to see that three of the largest sort of French transport companies are all sort of putting their foot down and saying that we want to be part of the bidding process when this comes alive. So TGV, Thales, and Alstom all are sort of putting their names out there and saying we want to be part of this. Notwithstanding the fact that there's a lot of economic activity going on in ASEAN, obviously this is there are a lot of emerging jurisdictions. We can talk about Myanmar, Indonesia, Vietnam, and a lot of these countries are still at a very young stage of development in terms of their legal infrastructure, in terms of the political infrastructure as well. And so there is a lot of uncertainty, I think, about the risks involved in investing in these countries. And along with the regulatory risks and the commercial risks, I think companies are very eager to find ways to protect themselves and make sure that if there is a problem down the road, that they will have a secure form or platform for dispute resolution. So one of the traditional forms of dispute resolution in Asia and around the world has been commercial arbitration, of which, of course, Benoit and his colleagues are famous for. And he's absolutely right that the ICC has been in Asia for the longest time, and I think the ICC is very familiar to most of us in this room. A competitor that has emerged is, we like to think, the Singapore International Arbitration Centre. Over the last few years, it's been improving a lot. Last year, I think we saw something like 200 over new cases registered with the SIEC. About 80% of those new cases involve an international party, so someone that is outside of Singapore. So the market is no longer domestic, but we're looking outwards. And amongst the top users at the moment, unfortunately, we have not seen a lot from the European countries, but you'll see that China, US, India as the three largest users of the SIAC. So some people have asked me before whether or not Singapore is a good seat when you have Euro-Asian joint ventures in particular. And I think the answer to that is yes. And you see a lot of Asian countries willing to put Singapore as the seat of arbitration. Particularly if we focus on China for just one moment, I think China internally is facing a lot of difficulties with CTAC and with the Shanghai Arbitration Center because of the internal struggles between them, and there is a lot of uncertainty about whether an award from one of these institutions can be enforced outside or even within China at the moment. And to be very, I mean, Hong Kong has obviously always been there and has always been a great seat for arbitrations in Asia. But increasingly, I think people are looking elsewhere because of the proximity of Hong Kong to China. So if you have joint ventures with Asian parties, I think one place to possibly consider is the SIAC and Singapore. And as Poon also pointed out, the Singapore jurisprudence is very advanced, very sophisticated. By and large, we follow the English common law system, which may not be the best thing in the world, but you will be pleased to know, as I was sharing with one of the associates just now, that we are a model law country. And a lot of the model law countries and jurisprudence actually comes from civil law jurisdictions. So you will see one of the interesting developments in our courts is references to French jurisprudence, to jurisprudence from Germany, jurisprudence from Quebec even. So we are looking around the world in terms of trying to understand what arbitration is, what parties want, and what they desire. So this is really a very interesting development for us in Singapore. And again, another source of potential collaboration with all of you in terms of understanding and learning more about the civil law system. Just very briefly on Cambodia and Myanmar as two emerging cities as well in Asia. As Benoit says, the landscape in Asia is really changing, and everybody now is looking to arbitration as a source of dispute resolution for transnational and international contracts. And in Cambodia recently, they have opened a commercial arbitration center last year, and Myanmar is now looking to ratify the New York Convention. It's been a while, but they say they're looking into ratifying the New York Convention, and they have draft rules in place now which follows the model law for arbitrations in Myanmar. So you'll see there's quite a lot of buzz in ASEAN countries about arbitration, generally speaking. And so there are a lot of options for you if you're looking to invest in that part of the world. Now, one of the very new things that has just started in Singapore in 2015, this year, and I'm very excited to share this with you, is the development or the opening of the Singapore International Commercial Court. And this is a hybrid between traditional forms of arbitration and also judicial proceedings in court. And what it tries to do is to borrow a lot of the procedure from arbitration, but also supplement it with some of the traditional strengths of judicial proceedings. So just by way of comparison, let me just back up one second to explain how this is structured. So the Singapore International Commercial Court is a division of the Singapore High Court. So it stands as part of the national judiciary. What you get at the end of the day is an award from the Singapore courts or the SICC, but it's part of the Singapore courts. It sits together with it. The infrastructure is still within the National Courthouse, but its aim is to capture international contracts and international disputes. And so it's carving out something similar to the English commercial courts or the Dubai international commercial courts. Is looking at resolving disputes, particularly where there's an international element. But it recognizes that, of course, international parties don't want to subject themselves to all the uncertainties of domestic legislation and rules and procedure. So it adopts a lot of the things which are familiar to us in international arbitration. So, for example, you can choose your own counsel. I think this is a huge advantage to international parties. You don't have to instruct a Singapore law firm or Singapore lawyers. You can prove foreign law by submission instead of getting an expert, which in common law systems is how we do it. The default is confidentiality in the proceedings for international cases. We don't apply our own domestic rules of evidence. So the IBA rules, for example, which you're familiar with, will probably be the default. And other areas like specific discovery, I think it's an issue. One of the areas of difference between the common law and the civil law systems is that the common lawyers like to ask for a lot of documents, and so the procedure is different for the international court, where it's only specific documents that you can request for. So these are some of the similarities that you'll find with arbitrations in the Singapore courts. And I think that the key point here in terms of access to the international courts is foreign representation. And there's a process to register a foreign lawyer before the international court. But by and large, I think the understanding is that once you apply, if it's an international case, you will get the permission to appear before the Singapore courts. So this is, I think, a huge plus for all of us who are looking for an alternative source of dispute resolution. Let me touch on some of the differences with arbitration that may be important to you depending on your commercial considerations. One of the key differences, and some people say it's a disadvantage, is that you don't get a New York Convention award. So at the end of the day, you will get a Singapore judgment. Singapore is a party to, right now, the Hague Convention, as well as the reciprocal enforcement of Commonwealth judgments. So it depends on where you think the enforcement is going to be. If you think it's going to be within the Commonwealth, that includes India, England, and all the former British colonies, then it's okay. It's still fine, and we can enforce the Singapore judgment in those countries. But if you have a potential enforcement outside of the Commonwealth, then this may not be a solution for you at this point in time. Perhaps until the Hague Convention comes into force around the world, or I think the government now is sort of looking to develop bilateral relationships with various courts around the region. So we have understandings with some of the Australian courts as well that they will enforce our judgments as if it was one of their own. So we are trying ways to expand enforceability, but depending on your commercial considerations, that may be a minus or a plus depending on where you come from. The other advantage is that the rules allow for joinder of third parties. And nowadays, of course, in a lot of the arbitration rules, you have provisions for joinder and consolidation. But it used to be one of the weaknesses, potential weaknesses in arbitration, where you have perhaps syndicated loans, or you have multi-party contracts, or string contracts, back-to-back contracts, and you think that you want everybody in one same set of proceedings. Sometimes it can be difficult in arbitrations, but of course in judicial proceedings, because of the compulsory jurisdiction of the court, they feel more able to join third parties. So there's provision for joinder under the international court's rules. One very interesting point of difference between international arbitration and the commercial court is that you don't have a choice of who your tribunal is. The tribunal is appointed by the Chief Justice from a list of international judges as well as Singapore judges. But what you'll be pleased to know is that there is a French judge on the panel. So these are the list of international judges that we have, the 11 of them at the moment. as well as the Singapore judiciary. And to just pick up on something I said just now about how Singapore is trying to be more international, you'll see that we have tried to reach out to the civil law jurisdictions by appointing an Austrian judge, a French judge, as well as a Japanese judge on the bench. So that in the event that you have a civil law dispute, there should be some expertise on the panel from which we can draw from and to adjudicate the case. This list is just the first list that has been published by the court. Obviously, over time, the list will expand depending on where the cases are coming from. I think if there are more French cases, you'll find more French judges on the panel as well. Just to give you an update, at the moment, the International Court has 2 cases, both of which our firm is involved with. The first case has a panel of 3 judges, one from the UK, one from Singapore, and one from Hong Kong. The other case is presided over by an Australian judge. These are both cases where there's no Singapore element whatsoever. They are international parties. One of them is Australian against an Indonesian company, and it's over a joint venture mining dispute. The other case involves a share transfer agreement between a Chinese and an Indonesian party. So again, no Singapore connection, it's not Singapore law, but they have found their way into the court. These were cases which actually started in the Singapore courts, the regular Singapore courts, and then they were persuaded to move the cases to the international courts. So it's an experiment for us. Perhaps this time next year when I visit France again, I will have something to update you in terms of how the procedure has gone. But so far, the early indications are that they run it a bit like arbitrations actually, memorial styles. The procedure is quite very similar to what we see in arbitration. So there's hope that in terms of at least procedure is something we are all familiar with, and it's not domestic in that sense. Perhaps the last point of difference with arbitration is the ability to appeal the decision of the first instance tribunal. This is controversial, of course, in international arbitration. A lot of people say that this creates another level, it slows down the process. But the good news is that this is an option. You can opt out of it if you don't want a further review by the Court of Appeal. But if you do, the option or the availability is there. Again, I think this is a response to some criticism of international arbitration in the sense of being uncertain about the quality of the panel that you sometimes get in arbitrations. So the appellate function is meant to provide a certain level of protection beyond the first instance. But again, it's not for everybody, but the flexibility is there to choose if you don't want it. The other innovation, it's not really an innovation, but option that has been put on the table by Singapore is the International Mediation Centre. We have always had a mediation centre, as most, I think, jurisdictions will have, but we have decided to internationalize it over the last year. And again, the idea is to capture international parties, either looking to mediate as the primary means of dispute resolution, or potentially as part of other proceedings, as part of arbitration, as part of judicial proceedings. You feel at a certain stage of the proceedings you want to choose arbitration as mediation. That is an option that is available at the moment. And one of the interesting developments or protocols that has been developed in conjunction with the SIAC is the up protocol, where you might start with an arbitration. Maybe after pleadings or document exchange, you find that there is an opportunity or window to mediate. You can stop the arbitration proceedings and say we want to now refer it to the mediation center. If you get a good resolution from the mediation center, you can come back to the arbitrator and get it written out or recorded as an award. so that you get an enforceable New York Convention award that is basically consensual between the parties. So that helps you to enforce it in the future in case the parties fall out again, which sometimes happens. Again, as Poon noted, we are not only seeing developments in the commercial arbitration environment, but also in the investor state arbitration environment. And one of the newer agreements, which I think will become more and more important for us, is the ASEAN Comprehensive Investment Agreement. I won't go through all the details, because a lot of the provisions for protection of foreign investment is the same as you will find in most other bilateral investment treaties. So you will have things like fair and equitable treatment, protection against expropriation, protection against unfair judiciaries, and so on. But the important thing is that if you have an investment in an ASEAN country, either through a holding company or you have set up a vehicle in an ASEAN member state, that opens up a possibility for you to consider potential recourse against the ASEAN governments if you find that what they've done is unfair to your investments in Asia. So this is, I think, to protect, particularly in developing countries. There's a lot of investment pouring into Myanmar and Vietnam, Cambodia at the moment. But of course, the environment, as I said earlier, is very uncertain. A lot of our experience has been that emerging jurisdictions will be very welcoming to foreign investment for a period of time when it's very intense, and then they find that they need to tweak their economic policies as they go along, and that sometimes creates difficulties for foreign investments and foreign investors. So there is, you can be assured that there is now a sort of a level of protection given by the ASEAN Comprehensive Investment Agreement. So let me just touch briefly before we open for questions on two interesting developments that we see in the ASEAN region. The first is cross-border enforcement of judgments in ASEAN. As I said previously, the Singapore government in particular has, because it's in our interest to promote this, has been pushing ASEAN governments and our neighbours to sign up to the Hague Convention. That's one way that we're trying to link up with the rest of the world. But we are also on our own trying to develop bilateral arrangements with the courts of various countries in ASEAN, so that if you get a judgment of the Singapore courts, you can enforce that in the rest of Asia, where your competitors might have assets. So that is something that we are looking into very, very keenly and with a lot of enthusiasm. The other interesting development that you'll see is that we are pushing to try and harmonize certain aspects of the laws in Asia, and I think this hopefully will be of interest to business in particular, because at the moment, at least the sense that we get from our clients is that ASEAN is huge, but also an exciting as a business prospect, but the laws are so different between countries that it's often a black hole. No one really understands what laws operate in each of these environments. You sometimes have a mixture of the Indonesian laws, which are based on the old colonial Dutch laws. You have the Vietnamese, which are based on French laws. You have Singapore, which is based on English laws. So it's difficult, and it's not an easy place to do business in because of the differences in the laws. So one of the things that the Singapore judiciary and the government is trying to do is to develop tools or to develop platforms similar to, for example, the efforts made by the UNIDROIT in Europe to develop principles of contract law that can be applied throughout Asia. So we are trying to look at like the CISG, for example, as another model for sale of goods. And I suspect corporation laws will also be another area that we will try to develop common systems and harmonized systems across Asia. so that when you know you're doing an investment in Asia, you have something to fall back on, and you know and what is there, and it's transparent. So there's a huge conference that's going to happen next year. You're all welcome. I can send around details to Benoit, and he can disseminate it. If you happen to be in Singapore in January next year, there's going to be a huge conference where we're going to push this out. And we're going to launch the Asian Business Legal Institute, where most of these developments of harmonized laws will take place. And I think the Singapore government will be very interested to hear your views about how we can develop ourselves in a way that is friendly to European business doing investments in Asia.